The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to our webinar series. This is a webinar brought to you from the Cloud Industry Forum Legal Group, and it's designed to help our members to understand and consider some of the implications of the recent Brexit vote. Obviously, they say a week is a long time in politics. It's about a month now since the vote, and certainly the ramifications seem to be still playing out in a very uncertain way. What we'd like to do in this session is just to bring some expert opinion from our legal forum about the broader context of what's going on in Europe and how Brexit might or might not impact that. And to do that and to run you through this, I'm delighted to welcome Connor Ward, who is the chair of our Cloud Industry Legal Forum, and he will be joined by Mac McMillan from Hogan's. We're also very pleased that Gemma Farmer, Senior Policy Officer at the ICO, will be able to join us, and our own Julian Hobbins from our General Counsel here at CIF and FAST will run us through some of the EU-based activities. So with that, over to you, Connor.
Thank you, Breda. I guess one of the uncertainties in relation to Brexit is the extent to which we've got numerous uncertainties. And it is still very early days for organisations to fully understand the consequences of Brexit. But unfortunately, we are to a certain degree tied to a number of timetables. Firstly, there is the timetable in relation to the implementation of new legislation that's coming through from Brussels, that's already in the pipeline, and which we may and most likely will have to comply with, because the timetables that the legislation which we look at will not align with the Brexit timetable. And once negotiations start to come to a conclusion, we may have a better idea as to what the delta will be. And as part of this webinar, I think that to best understand the consequences of Brexit, we first need to understand what pieces of legislation and initiatives are emanating from Brussels which have a direct impact on cloud computing service providers. So to that end, if I look at the agenda, what we will look at today are a number of the activities that are taking place at an EU level. So these are very much work in progress, initiatives that have commenced some years ago, or in some cases only a couple of months ago. We'll have a look at some of the regulatory and supervision issues that might apply to cloud, both at a UK level and a European level. We will have a canter through the legislative landscape as it applies today, with a particular focus on data protection and the privacy shield, both of which are applicable as of today. Then we've got the General Data Protection Regulation, which is enacted, adopted, but not yet fully enforced, but it will come into force during the course of the next 2 years. And the NIS Directive, which was adopted by the Commission, Parliament and Council on the 6th of July, published in the official journal on the 19th of July, and will be effective in May 2018 again, so we'll talk about that. And then last but not least, we'll have a panel discussion around matters arising, and we will be taking questions from the audience. So moving swiftly on, I'm looking at a couple of initiatives that are coming out of Europe from the Commission. There are a number of, one has to remember there are a number of different Directorate Generals within the European Commission, and in some respects one has to appreciate that when we talk about the Commission, we're talking about multiple different departments, and many of them run initiatives in parallel, unfortunately often without coordination. But one of the biggest initiatives that emanated in 2015 was around the digital single market. And It's to boost the digital economy across Europe between now and 2020. It's broken into 3 pillars. The third pillar included a very detailed initiative on a European cloud initiative. And the Commission said that they would implement their initiatives in relation to cloud by the end of 2016. Now that is possibly a little bit optimistic, but one needs to bear in mind what they were looking at. Some of the proposals included certification of cloud services, and Julian will talk about some of the steps that have been taken already in that regard. They are very keen to facilitate the switching of cloud service providers. The Commission has got it in its head that there is an inability for users, both consumers and businesses, to migrate from one cloud platform to another, and therefore it's looking at a variety of proposals which may be introduced by way of legislation at some point to facilitate transfer between one platform and another. And then it's very keen to look at and encourage the use of the research cloud. This is an initiative that runs parallel with its idea of big data, which we'll come on to in a minute. Specifically, though, in relation to the European Cloud Initiative, the Commission has said they want to have an open science cloud. The proposal there is that it will enable the 1.7 million researchers and 70 million science and technology professionals, these are the European Commission's numbers, 70 million science and technology professionals to have a virtual environment so that they can store, share and reuse large volumes of information generated by, as they call it, the big data revolution. The Commission is also very keen on encouraging and facilitating European data infrastructure, which is linked with the high performance computing also, which they mention in their information and communications in relation to the initiative. Now this doesn't come cheap. The cost associated with this is allegedly 6.7 billion euros, of which 2 billion will come out of the Horizon 2020 budget, and the rest will be financed through public and private financing. Now from a UK point of view, of course, once we announced that we are in Brexit, the question is the extent to which we will be excluded from any of these initiatives, in particular when it comes to financing and funding of projects. I think that's practically going to be a reality, that if you are a UK cloud service provider based in the UK, you may find it more difficult to get funding from these funds and these projects than if you were based in Germany or Italy or Ireland for that matter. So that may well be something that cloud service providers will have to consider if they have solely a point of presence in the UK. If they have a point of presence in other jurisdictions, they structure any requests for participation in schemes and fundings, etc., etc. So that's the Cloud European Initiative. If we can then look at, whoops, sorry, the technology is a bit slow here. Hang on, change slides. Do that again. Okay. Another policy initiative that is very much in favour with the Commission at the moment is in relation to open data and free flow of data. In fact, this is also something that the UK government is very much in favour of in relation to open data with initiatives such as My Data, which applies to utilities and financial institutions. The Commission produced a communication in 2014 towards a thriving data-driven can't see that, economy. And again, it was the Free Flow of Data initiative was mentioned specifically in the Digital Single Market communication. There are references to data in a number of other communications from the Commission around the digitization of European industry and specifically in platforms. Platforms also, the investigations and consultations regarding platforms links cloud as well as data. We will see an awful lot of activity in this area in the next quarter. and towards the end of this year. There's going to be a ministerial roundtable in September to look at data issues. And one of the things that the Commission has said is that they hope to have legislative proposals by November of this year, including options around technical standards, facilitating switching and portability of data. And you'll see the common theme here about portability from platforms, from cloud service provider to cloud service provider. Again, the question is the extent to which UK-centric cloud service providers will be affected by this and will be able to influence any of the policy decisions that are being made. And this is a big issue. We've had discussions with DCMS in the UK. The big issue is around the regulation. Will the Commission implement regulatory requirements around portability, around standards? And one other area that they're very interested in is in big data, accessibility of data, both in the public sector, but increasingly in the private sector. They believe that there is very many billions of euros tied up in data which is not freely accessible. And so there's a big consultation going on in relation to the ownership of data and the rules requiring compulsory licensing of data. Not so necessarily so much an issue for the cloud service provider per se, but as cloud merges and migrates into the Internet of Things, and the other driver in this, pardon the pun, is driverless cars, where they think a lot of information will be available, mostly stored in the cloud, and that should be freely accessible. All right. Next. Now, in relation to regulation and supervision, there have been a number of initiatives from various parts of the Commission. DG Connect, which is responsible for technology and has a specific department looking at cloud and software. DG Justice, which is just the legal team who sit in their ivory tower in splendid isolation, talking to no one. They both implemented studies on cloud contracts. DG Justice set up a working group to look at setting out a pro forma, a standard form contract for consumers contracting in relation to the cloud and to the cloud. That initiative went nowhere fast, as they realized it was extremely complicated as to how you could have a model contract or even a standard contract that should apply across Europe, given that the complexities of contracting for the cloud, the liability issues and other terms and conditions such as SLAs that give cloud service providers their competitive advantage. Nonetheless, DG Justice commissioned a study on cloud computing contracts, which was from all good bookstores, in particular from the European Commission, and it is free. The next question then is whether or not we should, or the Commission should could force compliance with their ideas of good practice, and to that end they consulted earlier last year on contract rules for purchases of digital content, which they included cloud, and they also included not just cloud platforms, so infrastructure as a service, but also content, including software as a service. The Cloud Industry Forum was very active in trying to persuade the Commission that this wasn't a good idea, as it opened an awful lot of very complicated legal issues in relation to product liability, and why should cloud services be marked out from any other service that's provided to the consumer or SMEs. Nonetheless, expect the Commission to produce proposals on digital contracts. Whether they will be mandatory or advisory only remains to be seen. But this is something, this is a bee that is very much in their bonnet. Now, the flip side of all of this is that from a Brexit point of view, we might actually find that we are able to sidestep any requirements that the Commission comes out with in relation to digital contracts, at least where you're dealing with UK-centric organisations. On the other hand, if you are using the UK as your cloud base and you're selling services to customers within the EU and member states, it is probable that you will have to comply with some of these service requirements if they become mandatory, as the Commission is very much alert to the fact that providing services from offshore should not be an excuse to sidestep EU-focused legislation. And that is something that we will touch upon time and time again later on in the talk in relation to the General Data Protection Regulation and the NIS Directive. So, whilst the Commission and DG Justice is merely beavering away and looking at cloud contracts and what should be imposed on the industry, we have the Competition and Markets Authority in the UK. They produced a compliance report back in May of this year, 27th of May, and they concluded that in relation to consumer contracts, and in particular in relation to cloud storage for consumers, there was no need to regulate. They thought that the market was dynamic and fast-moving, and whilst they thought some of the contract terms may not be enforceable from a consumer protection point of view, they did not feel the imperative to intervene, and hopefully that will remain to be the case at the European level, but I fear influence at the EU level becomes diluted, if not non-existent, then the voice of common sense and reason that has been the stalwart of UK involvement in the EU for the last couple of years will not be heard, and we'll end up with a German approach. And Mac laughs. Finally, I would mention that there are a number of certification standards and compliance requirements that are going to emanate from Brussels in the next 12 to 18 months. And these have been in the pipeline for some time. One came into effect on the 1st of July 2016 in relation to the digital EID regulation, which deals with trust services and digital identities. That is a regulation and became effective automatically. So we've now got one law applying across Europe in relation to identities, the certification of trust service providers, and the technical standards to apply. Obviously, if we leave, there may well be some issues there. The reason I mention that is because the Commission has latched onto this regulation as being a possible route to certification for security standards in a number of areas, including in relation to Payment Service Directive number 2, which does impose specific requirements on security and reporting. The NIS Directive, which is the Cybersecurity Directive, which I mentioned earlier, and we'll go into detail in a little bit later, and the GDPR, which also has security standards. The European Agency in relation to Network and Information Security, ENISA, will be responsible for drafting these standards. And to give an idea of where they're coming from, you can look at some of the good practices and recommendations they've produced already, specifically those in relation to financial services, one of which was published in December last year, and also in relation to the standards for so these areas we have to grapple with already. The timelines for many of them go into 2017, 2018, so we're going to be running in parallel with Brexit, and one of the issues we have to then, as an industry sector, we have to grapple with is which of these regulations and directives and recommendations do we comply with, which ones can we ignore, and I fear at the moment there is not a lot that we can say, save that for some of them there's probably going to be not a lot of change even if we leave Europe, because if our cloud service provider is trading in Europe, they will probably have to comply with European legislation regardless. Now on that, to that end, I will hand over to Julian, who attended a recent meeting at the Commission with regards to cloud initiatives under the auspices of DG Connect.
Great, thanks Connor, that's really good, and Connor's going to do me the favour of dealing with my slides, although one of my slides there looks like it's got half of his slide, but that's purely unintentional. So I was asked to give some words, present on the C-SIG meeting which I attended, and I guess that the auspices for this were, what does Brexit mean for cloud service providers? The big question, it's also the same question that is in a number of other policy fronts in the IP sector as well. What does it mean? So that is what I attended on the 27th of June in Brussels. If I could ask Connor just to sort of ping me over to the next slide, that'd be great. Just a bit of background here is that for me is that I'm an IP lawyer, and I work with the FAST hat on and also the CIF cloud hat on. And if you like, I'm involved in policy work and initiatives and trying to do good things for the cloud industry on the supply side. So I thought I would just come up with some information, some words on, what is a C-SIG? You may not have heard of it in this context, and Connor very earlier referred to certification of cloud services and the like, and really they are work streams. This information is all on the Commission website, and I can, after this, happy to provide details of that. But there are a number of cloud select industry groups. There are 3 in total, work streams, if you like, working on what I would call personally, from a personal point of view, a soft law sort of approach and a sort of self-cert or self-help approach, guidance, soft documentation, established by the Director General for Commission Communication Networks, Content and Technology, Software and Services Cloud Unit. And at the C-SIG meetings, there are representatives from major European multinational companies, as you can see, organizations with significant involvement in cloud computing, etc. So that is if you like, the stakeholders in the room to provide independent validation and advice on proposals. And really the genesis for this is a paper a couple of years back now at least, or slightly more than that indeed, time's marching on, and unleashing the potential for cloud computing in Europe, and then which identified key actions to be supported by the C-SIGs, or the Cloud Select Industry Groups. So that just gives you a little flavour of what they are and why they exist. And it really is a partnership of a number of stakeholders there, from industry, from the big guys, through to consumer organizations, to trade associations, to the Brussels bureaucrats, I suppose. We have those also they come out of the ivory tower from on the legal side and attend the meetings. Well worth going to. And Colin, if you could just ping me over to the next slide, I'll just talk some more about this. So just a bit more information on the C-SIGs themselves. There are 3 which are in this line of work. The first being the Cloud Select Industry Group on the Code of Conduct, and that really is on data protection, as I would refer to it, privacy. Just sort of number and this on the Cloud Select Industry on service level agreements, some more sort of work there towards the development of standardization guidelines, and lastly Cloud Select Industry Group on certification schemes. So quite a bit of work going on following the digital single market strategy, and there's a whole bunch of work which extends also to IP. But for the purposes of this discussion today, we're going to focus, and I'm going to focus on what happened in the meeting on the 27th of June in relation to the Cloud Select Industry Group on the Code of Conduct for Data Protection. And I think if you just read the top of that slide below the first bullet point, it says the Code of Conduct will support a uniform application of data protection rules by cloud service providers. So the whole thrust of this is to have uniformity across the EU. Obviously, query what does Brexit mean, and indeed that subject did come up. Although the question is whether it really had any influence or impact at the meeting at all. So let's move on. Next slide, please, Connor. Okay, so as I said, I went to the plenary meeting. This is the overarching meeting on the 27th of June. The last meeting before that was the 29th of October in Brussels at the European Commission, and held at the Director General for Communication Networks, etc., etc., and cloud. The meeting objectives were to discuss the finalization of the Code of Conduct and Data Protection, which I call the Code, to discuss cloud computing policy and related issues arising in the context of digital single market strategy, including the free flow of data. Now, the free flow of data, I'm pleased you mentioned that, Connor. It's something that people have been mentioning to me. I was just interested in getting my head around that as much as I could as we progress, and keen to understand really what that kind of meant within the single market. Any role of the C-SIG in cloud certification and standardization, it really is the thing is certification and standardization across the board. And there was also a little typo of mine here. It says a presentation of the results on the study of measuring the economic impact of cloud computing in Europe by Deloitte. And that's well worth a look. I'm not going to refer to those slides right now, but that's well worth a look in the study and gives information about how that is progressing. Next slide, please, Connor. So really what I wanted to do was, in the meeting as a stakeholder, perhaps as much as an observer, as much as anything else, just to understand the commentary if we're thinking about data protection as such, and considering the context of the regulation, which is obviously, you know, coming down the road or is with us. Commentary on the code of stuff. I mean, there was a few opening comments from Piers O'Donoghue, who leads the unit, very eloquent and sort of marches the meeting along, made a clear statement. Obviously, the law overrides the code of conduct, which may be produced by the C-SIG. But it was notable, actually, that the code is very, very useful in terms of a practical approach to being flexible within the bounds of the law. So I think the code of conduct work was very well received, and definitely has a future, and that's really the question is going forward. But I just wanted to give a bit of context in relation to what happened in relation to the Working Party 29. They are the sort of, if you like, the data protection, I don't know what I call it really, unit overseer, giving decisions, opinions on data protection law in the European Union. And they, on the 22nd of September last year, they actually came forward and gave an opinion on the C-SIG code. And they're quite supportive, really, because obviously the industry is driving for, as I would see it, not an over-regulation. Want to do business in Europe, simple as possible, you know, provide services to customers. And so the Working Party expressed its appreciation to the effort put in by the industry and recognised that the code provides an important guidance to cloud computing providers with regard to applicable data protection and privacy rules in Europe. So this is good news. This is something practical, bit of, if you like, you know, something that can be used to understand how you progress in business, rather than, some would suggest, appear opaque. Adherence to the code of conduct will contribute to greater transparency, one of those famous words at the minute, transparency, and another one, phrase here, lawyers love legal certainty for all parties involved. There was a couple of points coming out of there, more than a couple of commentary from Working Party 29, that the code, you know, will help demonstrate compliance, but obviously it doesn't give automatic protection against possible interventions or actions by data protection authorities. So obviously that it's simply what I call soft law advisory, so on and so forth. But it's good work. But Piers at the start of the meeting had some overarching comments on that. Next slide, please, Connor. So I was thinking, well, how do I explain really what came out of the meeting on this code of conduct for data protection? And I thought, well, a list is as good as anything. I could have put some pictures up. But it was interesting that Piers was saying that one cannot pick and choose if you want to, you know, abide by the code. You must comply with all of it, or none of it. You couldn't sort of pick bits out. There was a sentiment in the room against proliferation of codes from various sectors. So, for example, there was a code from another organisation representing a number of CSPs, cloud businesses, and there was a certain view that perhaps one code, the code from the C-SIG, should be the code, and others should tie in with that. And I'm just having a look. If you look further down that slide, and there were some comments made in relation to that, for example, whether technical standards can be used to map to the code so that everything dovetails within it. The code has a life. It's obviously been through the Working Party 29. My next slide talks about whether that it should be approached again, but they've got to work out the governance going forward, the secretariat for the code, the life of the code, and how it's used and how it's got out there. A question of which came up, sort of recognising existing standards and schemes in the context of the code. I think that, the general view is that the more tie-in with that, the better. The code it's still in draft. It's not signed off at the minute, and there's a clear consensus that this work's still to be done, so on and so forth. And another thing about which came from the Commission was, and also from a vendor perspective, large global vendor perspective, is that it'd be good to have an SME how-to guidance for cloud service providers in relation to the code, and that's useful because sometimes, unless you kind of live in this world, when you need your top tips, your advice about how to deal with the practical aspects of it. Next slide, please, Connor. Thank you. So, anticipated objectives. So the general mood in the room in relation to this code was to go back to the Working Party 29 for approval and try and get some further feedback from that particular Working Party on a revised draft, considering their previous feedback. And also, I don't know, it's a question for Gemma here perhaps, but to have a look at getting some feedback from the National Data Protection authorities, a few there, I suppose, and also to get it out in the market and say, look, to secure some feedback on it and say, look, does this really tick the box? I guess that the commercial people may say, does it give us protection from a regulator, etc. Of course, it doesn't, but that might be something to get some feedback on. I expect the feedback from the market will be also, in a commercial point of view, a practical point of view, is that how do you actually align yourself with the code? How do you, tick the boxes? How do you show that you've done X, Y, Z? And the easier and the simpler that is, without undermining any of the heavyweightness of the code, would be particularly useful. Next slide, please, Connor. So, a big question here, and it's one of those slides where you're wondering whether it's just all there is to see, or there's perhaps more. But were any parts of the code discussed? And actually, there was complete silence on that. That the work, I think that the stakeholders in the room were of the view that the work had been done over a number of years. The draft had been put to the Working Party 29 committee, and that we didn't need to go through it in the plenary session. It was just there to update anyone. So there weren't any parts of the code per se that sort of gone through, for example, in relation to liability, etc., etc. So I don't know if that's the news you wanted, but that's kind of, it wasn't gone through in the meeting, and it's work in progress. So no is the answer to that. Next slide, please, Connor. Okay, and a Brexit. I didn't know what to really write here. I wrote down zip, which means, I guess, that really just didn't feature in the conversation at all. Brexit, it was just simply far too early, and this was, very, very soon after the vote, and it was hoped to be business, I think, as usual in the room. And Connor's made their point is that you're selling those cloud services into Europe, then that you'll probably need to align anyway, and it's just too early to tell. And a Brexit per se, I think there's a lot to be done, a lot of reorganisation. Just by way of analogy, I just found out yesterday in relation to IP that the Chief Executive of the IP office has been hauled off somewhere else in relation to Brexit, so that perhaps that may happen also in relation to other parts of the government too, that there's a reorganisation. So if we hear any news on that, and there may be some from news for us in due course on that. But one of the some of the key points, a couple of key points, and which kept coming out, is that there was a points made in relation to data localization restrictions, free flow, and the issue is of local law applying to contracts more where the data center is located. A mix of laws is the issue, so simplicity and the lack of barriers across the EU market is certainly something which was wanted, needed, being pushed for continually, notwithstanding Brexit. Business as usual is the message I got from the room on that. Next slide, please, Connor. So what's next? Notwithstanding the fact that the code is still in draft, is yet to be published. There is some work in relation to sorting out the secretariat, pushing on with that, looking for schemes, looking for trust marks aligning with standards, and so on and so forth. And there might be an opportunity here for the Cloud Industry Forum, considering that the Cloud Industry Forum has been running its code of practice for cloud service providers. That might be an opportunity for CIF to be a stakeholder. I know it is a stakeholder. I spoke to one of the contacts, the chap who's running that, and CIF could be a scheme operator potentially in relation to the code of practice going forward. I think that's interesting. Hopefully shows that that's a good influence, good connections there. So that's really kind of where we are. The impression is that the Working Article 29 will be approached again for its opinion, advice, guidance. Doesn't endorse, of course, and there we are. So a public announcement, I guess, of the final draft in due course. I hope that what we don't end up with is a confusion or a proliferation of codes, perhaps some interested parties, and as that we all be nice to all tie into one particular. Sounds very European, doesn't it? One particular direction. But so there's more news to be announced. But I hope that was a useful update from my visit to Brussels on the 27th of June.
Okay, thank you, Julian. Now we'll hand over, when I get the technology working, to Mark Macmillan. Come on. Doesn't like this Citrix thing, does it? Didn't it just go to the right side? Yeah, I should be able to. Not coming up, is it? Oh, well. You just have to scroll through. Okay, cool.
Okay, so this is an update on what's happening on Privacy Shield. Oh.
No, yeah, it didn't come up, you see. What have you done? Apologies. We seem to have lost the slide. There we go.
Oh, excellent. So, to recap where we are very quickly on the history to this, European Data Protection Directive requires that if you are exporting data outside the European Economic Area, you must ensure that in some way the destination provides adequate protection. And one of the ways for doing this for the US was the Safe Harbor Framework. And that was declared invalid by the European Court of Justice in October of last year. So the European Commission had already been in negotiation with the US Department of Commerce for some time to revise that framework following the Edward Snowden revelations. So in February, it issued a draft adequacy decision with the proposed new replacement framework, which it christened Privacy Shield. The Article 29 Working Party reviewed that and said, well, you've obviously done a lot of work, but we've still got quite a lot of concern around this. There was then a sort of hiatus period where it wasn't clear what was going to happen, but further negotiations did take place between the Department of Commerce and the European Commission, and they published a revised framework and an adequacy decision on the 12th of July. And so the US Department of Commerce has said that from the 1st of August, the Privacy Shield will be operational and companies may file an online registration. So effectively, at the moment, Privacy Shield from the 1st of August will provide a replacement solution for transfers to the US. So how does it work? Well, it's broadly similar in concept to what we had under Safe Harbor. So it's operated by the Federal Trade Commission and the Department of Transportation. So US organizations need to be regulated by one of those organizations. So, for example, banking institutions are unlikely to be covered, telecoms won't be, some insurance companies won't be, but IT providers rather than telecoms providers should be able to benefit from it. It's a self-certification regime. It requires organizations to develop a privacy policy which conforms to the Privacy Shield principles, explicitly states that the organization adheres to those Privacy Shield principles, links to the Privacy Shield website so people can see what it's about, and identifies the organization's independent recourse mechanism for consumer complaints. And that last is one of the innovations, providing a mechanism for consumers to complain. The privacy policy must be made publicly available, and organizations must have a compliance verification process in place, and they have to do annually update their certification. So it's broadly similar to the ideas behind Safe Harbor. The Privacy Shield principles are the same but updated and strengthened. So how is it different? Well, proponents of Privacy Shield focus on changes in areas which are specifically developed to address the concerns of the European Court around government surveillance and consumer redress. So there are letters from the Office of the Director of National Intelligence and from the Department of Justice which explain how the US government surveillance network works and what limitations are in place. There is also an independent ombudsman within the State Department which is exclusively for European citizens to raise concerns with around government surveillance. If you raise a complaint, the ombudsman will verify that any surveillance measure has been law, correct any violations of the citizens' rights. And then there are also some elements strengthening consumer rights against the data controllers themselves. So obtaining consent from Europeans before sharing data with third parties, and creating rights similar to those under the directive to access, correct or delete data. And then in addition there's the right I mentioned before that controllers must provide an independent complaints mechanism for consumers which is free of charge. So what are the risks? Have they done enough? Does Privacy Shield give companies a workable solution? Well, the first thing to be aware with is that the way the enforcement works in the US is, well, it's the same as with Safe Harbor. If a company certifies it complies with the principles and it fails to do so, it may be subject to enforcement action for engaging in unfair or deceptive trade practices. And the FTC has levied some pretty swingeing fines in the past under that heading, although not in respect of Safe Harbour itself. There's also this enhanced redress procedure for European individuals. So if you sign up to this, compared with Safe Harbour, you may see an increase in complaints. And then the key thing is what will be the position in Europe. And the general expectation is that it will be subject to a legal challenge. So initially Max Schrems said he would be challenging it. He recently said in an interview that he was getting fed up with being the person who always raised the challenges and someone else should move this forward. But there are other privacy advocates and NGOs which have expressed an interest in this area who may well challenge it. Some colleagues of mine did a full review of the first release of Privacy Shield, so not the revised one. And their view was that it ought to meet the requirements specified by the European Court. So it's not open and shut as to whether, if there is a legal challenge, whether the court would overturn it or not. We think there is a reasonable chance it would be approved. But you know, that there remains the question mark if there is going to be a legal challenge, which company will want to be the first one to sign up to this if they're going to face a legal challenge. I am aware of US clients who are actively looking at it, but I don't know of anyone who's positively decided to go for it yet. So we have the new solution, but there does remain a question mark over how workable it will be, how popular it will be. Safe Harbour was very popular. It had over 4,000 companies signed up to it. I think that at least initially we'll see a much slower take-up in use of Privacy Shield until people see which way it's going to go. Although, of course, a further perspective on that is if the standard contractual clauses are being subject to a challenge already, you might find that signing up to Privacy Shield will turn out to be a fallback position in case standard contractual clauses get overruled. But that's where we are at the moment.
Okay. Thank you, Mac. We've talked briefly about the General Data Protection Regulation, which I'm sure everyone in the audience is fully aware of. Given the amount of publicity that's been given in the last 12 to 18 months, I will hand over to Gemma Farmer, Senior Policy Officer from the Information Commissioner's Office, who will talk us through the GDPR and the potential impact that Brexit might have.
Hello everybody. So today I'm going to give a brief update, as Connor said, on the ICO's current approach to GDPR in light of the current circumstances with Brexit. And I'll also give a brief summary of an overview of the GDPR that we published a couple of weeks ago, and I'll put that into context as well. So as Connor said, I'm a Senior Policy Officer at the Information Commissioner's Office, where I've been working for 7 years. I work in the Policy Delivery Department, which is responsible for producing external guidance and the ICO's research and projects. We lead on that kind of thing. So I'll begin by setting out what we know, kind of the current context in terms of the GDPR and Brexit. I think we've got to acknowledge, and as some of the other speakers have mentioned, that the detail around the future of the UK's data protection law and more broadly European law, it becomes a little bit uncertain following the result of the referendum a couple of weeks ago. And the only thing that is certain right about now is that the Data Protection Act remains UK's law and it's business as usual for most organisations. So over the coming months, the ICO will be engaging with DCMS and the government, and will be considering the implications of the referendum result and starting to look at its impact and the implications for data protection law in the UK. Clearly, it will be the government that sets that agenda and the timetable for any future plans or any future or potential reform. You know, at the moment, it's a little bit too early to say with any certainty what the role of GDPR in the UK might be, and the ICO as an office at this early stage, we're trying to get into too much speculation. But I think it's worth noting that Baroness Neville-Rolfe, who is the outgoing Minister for Data Protection, she's just got a new role since Theresa May has been appointed. She publicly stated in a speech that she gave at a conference shortly after the referendum that the government and stakeholders, including anyone who's interested, not just the ICO, other interested stakeholders, will all have to be sort of considering what can be done potentially to replace the GDPR if and when it ceases to come into effect, or in the event it never comes into effect. So it's very much on the government's agenda, and I think ultimately the message that we're giving at the moment is that the role of GDPR will be clarified once the terms of the UK's new relationship with the EU is agreed, and as we all know, that's very unclear at the moment. And that's broadly not just in terms of data protection law or the GDPR, but we need to wait and see what the government's position will be in terms of EU legislation that's due to come into effect pre-Brexit. One thing I think we can be reassured by is that the UK has got a long history of effective data protection law, and that's unlikely to change. We know that there's global acceptance of the need for good data protection and privacy laws. We know that consumer trust and confidence is essential to the thriving digital economy that Connor touched on when he was talking in his presentation. And we know that the government is placing great emphasis on growing the digital economy, and that's seen through the Digital Economy Bill that was in the Queen's Speech back in May. So the government's introducing measures to ensure that the UK is a world leader in that kind of area, and data protection and privacy is integral to and complements that work. So in the meantime, despite the uncertainty, the ICO we're intending to continue to provide the practical advice and guidance for organisations. And if I refer back to the Baroness Neville-Rolfe speech that she made at the Privacy Laws and Business Conference post-referendum, she emphasised that despite the uncertainty, the underlying reality that data protection policy is based on, that's not going to change. So for example, one thing that we can say is clear is that when organisations are sharing data across member states, or if you're processing data about EU citizens, this is always going to require an adequate level of data protection. And the government confirmed that that's central to their considerations going forward. Continues to be relevant. Our plan is to focus on the GDPR's key concepts, and it's those key concepts that are likely to be the building blocks that underpin any future data protection legislative regime. So that underpinning reality that the Baroness referred to. So whether we end up implementing GDPR, or we have a GDPR style law, or there's something completely different, we think those building blocks will be a constant. And this is why we decided to go ahead with publishing our overview of the GDPR, which we did a couple of weeks ago, post-referendum. It was all very uncertain. But this was the first piece of substantive guidance that the ICO has produced for organisations on the GDPR since the final text was agreed by the EU institutions. We published it because we still think the overview and the GDPR is going to be relevant for many organisations, because once the GDPR is implemented in the EU, it will be relevant for many organisations in the UK, particularly those ones who are operating internationally across Europe. So if you are a cloud service provider who processes the personal data of EU citizens, or if you transfer data across member states, the GDPR is still going to be relevant for you, whatever form the UK's future data protection law takes. So that means that many organisations in the UK will still need to understand the GDPR's main principles and concepts, and we hope that the overview that we publish will help them start to do that. So we've got a dedicated website, dpreform.org, and that's where the overview is published, and we've got some other resources on there, and we'll be adding to that over the coming months. And we did publish our guidance plan just before, a couple of weeks before the referendum result, and that identified some of the priority areas that the ICO will focus our work on over the next 12 months or so. And we'll continue to work on the priority areas that we've identified so far. So we'll be doing further detailed work on consent, on individual rights, privacy notices, transparency, probably accountability as well, maybe contracts between controllers and processors. And that's because if we reiterate that point that the Baroness made in her speech about priority areas being these building blocks, the underpinning reality that data protection policy is based on, we think they're going to change, and they're not likely to change, they're not going to disappear. So whatever our form of the UK's relationship with the EU, or whatever the form of data protection law takes in the UK, we'll have some resources and be able to assist organisations in preparing for that. So I'll give a brief summary of the ICO's, the overview that we produced a couple of weeks ago. I'll pick out a few of the headlines that are in the overview, but I would encourage you to go away and have a read of that. It's on the dpreform.org website. So we published the overview on the 7th of July, and the primary audience for this is information rights professionals who have a day-to-day responsibility for data protection. But if you're not an information rights professional, it's written in an accessible, easy to understand, high-level way. So if it's not your day-to-day job, we think that it'd probably be easy for you to understand as a starter for TEM in familiarising yourself with the GDPR. So the overview highlights some of the key themes in the GDPR. It should help you understand the new legal framework, and it identifies some of the similarities with the UK Data Protection Act, but also describes some of the new different requirements that are in there. So the overview explains that the GDPR has broadly similar principles and definitions to the Data Protection Act, but there's some sort of renewed emphasis on particular areas, and we think that these will continue to be those relevant building blocks in any future data protection reform that may take place. So the GDPR emphasises enhanced transparency and individual rights, that Connor also touched on earlier. The GDPR emphasises increased accountability and governance responsibilities for organisations. Much of that is about being able to demonstrate and document how you comply with the law. It also puts good practice tools that the ICO has long championed, so things like taking a privacy by design approach, or carrying out privacy impact assessments, appointing data protection officers, using codes of conduct. It puts those kind of good practice tools on a statutory footing. So all these areas are covered in some detail in the overview, but I'll cover a few of the key ones over the next 5 minutes. So a good starting point that is relevant for cloud service providers is to flag up who the GDPR applies to. So what's interesting about the GDPR is that it places specific legal obligations on processors, which is something that the DPA didn't do. So while the definitions of controller and processor are broadly the same under the Data Protection Act, for example, the controller says how and why personal data is processed and the processor acts on the controller's behalf, the GDPR actually places specific legal obligations on processors. So, for example, if you're a processor, you've got significantly more legal liability if you are responsible for a data breach, and you'll also be required to maintain records of the personal data that you hold and your processing activities, so what you're doing with that data. It's also worth flagging up that if you don't have an EU establishment, but you're offering goods and services, or you're monitoring EU citizens in some way, profiling them, that the GDPR will also be relevant to you as well. So moving on to a quick look at the principles. Under the GDPR, the data protection principles, they set out the main responsibilities for organisations, and they're very similar to the existing ones under the DPA. There's some added detail at certain points, and there's the introduction of a new principle, which is a new accountability requirement. It's also worth noting that instead of principles relating to individual rights or overseas transfers, those two topics are addressed in their own chapters. So I think it puts a bit of emphasis on them, really. There's two whole chapters dedicated to them. But ultimately, the most significant addition is the accountability principle, which is requiring you to show how you comply with the law. And the overview goes into some detail on the new accountability requirements. So, as well as being able to show how you comply with the law, which is a lot about sort of processes, a focus on processes, what processes you have in place, there's also that focus on good governance and introducing governance measures in specific circumstances. So if you're an organisation and you meet the threshold that's described in the GDPR, you might have to put some governance measures such as taking a privacy by design approach or privacy impact assessment or sign up to a code of conduct. You might be required to put those measures in place. The ICO has got some existing guidance on PIAs and taking a privacy by design approach, and that will still be relevant. We'll probably update that in due course. But the overview has some detailed sections explaining, one, your new accountability requirements, and two, when you might have to adopt those good governance measures. So in terms of consent, the GDPR has got references to consent and explicit consent, and in reality the difference between the two is not immediately clear, given that both these forms of consent have to be freely given, specific, informed, and an unambiguous indication of the individual's wishes. The GDPR is clear that silence, pre-ticked boxes, or inactivity will not constitute consent. So it's clear the GDPR is requiring some form. Also, linking back to the accountability and governance emphasis, consent must be verifiable, which means that organisations must have a record of how and when consent was obtained. It's also worth noting, if you rely on consent as your basis for processing data, and you sought that under the Data Protection Act or the Data Protection Directive, you won't be required to seek new consent once the GDPR is implemented if the standard of the original consent meets the new requirements in the GDPR. So if you rely on consent and you're starting to think about reviewing your processes, you might want to have a look at your consent mechanisms and see whether they already meet the standards required under GDPR, or whether you can start implementing some changes so by the time it's introduced, there's not a sudden bang and you're prepared. So as I touched on earlier, there is a whole chapter in the GDPR that's dedicated to the rules around transferring data outside the EU, and many of the requirements are actually a continuation of existing rules. So you can continue to make transfers where there's a Commission decision of adequacy of the third country. You're still able to rely on other safeguards, so BCRs, standard contractual clauses. You can still rely on those, and then there's the introduction of codes of conduct and certification, which may also be used to legitimise transfers. It's worth noting that the GDPR does limit organisations' ability to transfer personal data outside of the EU, where that's based on your own assessment of adequacy, so there are new rules around that to be aware of. And until so if your a transfer of data has been authorised by a member state or supervisory authority under the directive, those will remain valid until they're amended or replaced. So I'm conscious I haven't been able to cover everything that's in the GDPR or even everything that's in the overview due to time constraints, but I would encourage you as a startup attempt perhaps to go and have a look at the overview that we've published, and it's on our dpreform.org website. I feel like a saleswoman when I'm saying that. But that's a good starting point. And hopefully you've got a bit of a better understanding about the ICO's current approach in light of Brexit. The fact is there's a lot of uncertainty at the moment. We haven't got any kind of secret knowledge or indication of what might happen next. I think we're all waiting to see what the terms of the agreement between the UK and the EU will be generally before they get into the level of detail that's required to understand what will happen to European laws like the GDPR. But hopefully that's been helpful. Thank you.
Thank you, Gemma. That's been very helpful. I am conscious of time, but before moving on to the last session, which will be very prompt, I thought I would flag up that the big issue for cloud service providers who are deemed to be processing is that they have very often will have no idea what data their customer has put into the cloud, especially if you're providing infrastructure as a service. And this in itself will throw up some problems going forward with regards to record keeping and responding and replying to data breaches. But that's something the industry will have to grapple with. Moving on, my final slides are in relation to the Security of Network and Information Systems, the NIST directive, which was adopted earlier this month. It deals with providers of various services, but from our point of view, the main issue is in relation to digital companies, including cloud computing service providers. Cloud computing service providers are defined very broadly, basically a digital service that enables access to a scalable and elastic pool of shareable computing resources. Not the same definition as they use in the US, but a very broad definition. The important thing to remember is that if you're a service provider, you are caught by the NIST directive, which includes an obligation to take appropriate, proportional, technical and organizational measures to manage risk, to ensure a level of security is appropriate, and these items you will take into account, including business continuity, monitoring, auditing and testing, and compliance with international standards. What does it really mean to cloud service providers? Well, it'll introduce a mandatory reporting regime in relation to security incidents that have a substantial impact on the provision of the services, and the reporting will be without undue delay. Now, of course, there will be reporting under the General Data Protection Regulation in relation to personal data. If you're a cloud service provider, you will have a mandatory obligation to report in relation to any security breaches, regardless of whether or not it has personal data involved. What's the substantial impact? Well, we are given some criteria that the Commission thinks is relevant: number of users affected, duration, geographical spread, extent of the disruption, and the extent of impact on economic and societal activities. This comes back to the Commission's view that cloud service providers will be providing services that will be ultimately important, in particular to consumers and SMEs, and if they have an adverse impact because of an incident, then you will be caught. Now, what relevance is it if through Brexit we decide not to implement the directive? Remember, directives have to be implemented by a member state. Regulations apply automatically. So the General Data Protection Regulation will become law on the 25th of May 2018 without the UK government having to do anything. This directive, however, would have to be implemented by the UK government, and it may take the view that it's not worthwhile doing because we're going to leave the EU. Nonetheless, if you are a digital service provider or a cloud service provider who's not established within the European Union, but you provide services to consumers or customers who are based in the EU, you will be caught. The legislation has a long arm effect. It applies on an extraterritorial basis. So whilst the UK may not implement the directive, if you are providing services, you will need to appoint a representative in a member state where the services are offered. This does give you some leeway, however, to cherry pick which member state you may want to be regulated by. So, for example, you may be foolish if you want to be regulated by the Germans. You may think it more appropriate to be regulated by the nice Irish, because they will take perhaps a more business-oriented approach than, say, the Germans. Running swiftly on, the Commission has reserved for itself certain powers, in particular to specify the security and notification requirements. So we don't even have the details of what security you will have to implement, or the circumstances in which you would be required to notify for a material breach. ENISA, we touched upon earlier, the agency that deals with network and information security of the European Union, and they are going to be actively engaged in providing the security requirements and standards. Hopefully they will be consistent with the work they're doing for the General Data Protection Regulation, PSD2, and various other activities they've been engaged in. The industry must be consulted, and of course the Cloud Industry Forum will be actively involved in that. Timetable, the directive was adopted on the 6th of July, published in the OJU on the 19th, so it comes into force on the 9th of August. It must be implemented by member states by the 9th of February 2008. I can't be right, 9th of May I think it is 2018. Yes, 9th of May 2018, which is before the General Data Protection Regulation. So we're going to be quite busy, whether we look at Brexit or not. There's still going to be a lot of activity that has to be considered thoughtfully during the next 21 months with regards to security and the way that you organize your data. In fact, the way that you organize your organization may have an impact on your decision as to whether or not to set a data center up in the UK or another member state. I'm conscious we've overrun, so I'm going to finish there. And if anyone has any questions, by all means, raise them now, as Breda suggested, through chat, or feel free to email the Cloud Industry Forum, and we will respond accordingly. And I'll hand back to Breda.
Thank you, Connor. Yeah, in the interests of time, we won't spend a lot. I have had some questions come through. I think that both your own presentation and Gemma's have covered them in the main, but things like people asking, in the light of the uncertainties of Brexit, is it safe to do nothing and wait and see? And if you're providing services in both the UK and Europe, what should you be doing now? Would you have any closing comments around those questions before we conclude? One thing
I'll start first, and maybe Breda can I think in some respects organizations are in a bit of a state of limbo because there's nothing necessarily that can be done immediately. However, they should start thinking about steps that they may have to take, especially in compliance with the General Data Protection Regulation. They very much need to be aware of the fact that changes are afoot, and it is very much watch this space. If decisions are being made in relation to investments or in relation to upgrading technologies or location of data and data centers, it should be one of the questions that would be asked and considered, and perhaps whenever those questions are being raised, we will have a greater understanding of the likely direction that the UK is going to go in. And as I mentioned, in relation to organisations that provide services into Europe, you're going to have to comply with the legislation in any event, regardless of whether or not the UK replicates the European legislation going forward.
Okay, thanks for that. I think with that we'll wrap it up. I'd like to thank all our speakers. We have recorded this webinar, so we will make a link of it available so that you can share with colleagues and other interested parties the information. Also, we will forward the links to information that, for instance, Gemma raised in terms of specific places you can go for further information. And as I say, with that, I'd like to thank our speakers. Thank you for your attention. And we look forward to putting on the next webinar fairly soon. Thank you. Bye.
Thank you. Bye.
Bye.